Hey everyone, and welcome. If you're the kind of person who loves decoding the complex legal systems that shape our world, well, you're in exactly the right place. Today, we're diving into a highly structured explainer that breaks down the entire life cycle of Indian citizenship. We're going straight to the source using these detailed legal notes to map out the whole journey, from the foundational rights granted back in 1949 all the way to the highly discussed Citizenship Amendment Act of 2019. By the end of this explainer, you're going to have a crystal clear grasp of exactly how this vital status is granted, managed, and, sometimes even lost.
Okay, let's dive right into this. Here's our roadmap for today. First up, defining the Indian citizen. Then we'll look at how you acquire that status, followed by how you can lose it. After that, we'll cover overseas citizens of India, and finally, we'll break down the 2019 Amendment Act.
So, Part 1. Defining the Indian citizen.
Now, before we get tangled up in laws and amendments, we really need to nail down the absolute basics. What does it actually mean to truly belong to a political community? Our source notes define a citizen beautifully and simply. A citizen is an individual who enjoys full membership of a political community. That phrase right there, full membership, is absolutely key. It means you enjoy literally all the legal and political rights the state has to offer. You're not just, living there. You're fully enfranchised member of the whole shebang.
To really grasp what a citizen is, it kind of helps to look at what they aren't. Legally speaking, everyone inside a country falls into two main buckets: citizens and aliens. And actually, even within that aliens bucket, the law makes another split. You've got aliens from friendly states and aliens from enemy states. The rights you have heavily depend on exactly where you land in that breakdown.
So why does this full membership matter so much in your day-to-day life? Well, just take a look at these exclusive rights reserved only for citizens. They are massive. Article 15, that's your right against discrimination. Article 16 guarantees equal opportunity in public employment, meaning state jobs are reserved just for citizens. You get the 6 fundamental freedoms under Article 19(1). You've got cultural and educational minority rights under Articles 29 and 30. And crucially, Article 326 gives you the right to vote. Plus, only citizens can hold constitutional offices. These exclusive rights show exactly why this status is the bedrock of your civil life.
All right, moving on to Section 2, acquiring citizenship status. Now that we see how incredibly powerful this status is, the next logical question is, how exactly do you get it? The Constitution broadly handled the initial setup back on November 26, 1949. Article 5 laid out the rules for folks who were born or domiciled in India at that specific time. Article 6 dealt with people who had migrated over from what is now Pakistan. But, the framers knew things were going to change. That's why Article 11 is arguably the biggest deal here. It explicitly gave Parliament the power to make future laws about acquiring and losing citizenship, and Parliament used that exact power to pass the massive Citizenship Act of 1955.
And this brilliantly illustrates the result of that 1955 Act. The law created 5 specific ways to get Indian citizenship. First up is by birth, or jus soli, the law of the soil. Second is by descent, or jus sanguine, the law of blood, for kids born abroad to Indian parents. Third is by registration, which is typically for persons of Indian origin or spouses of citizens. Fourth is by naturalization, for foreigners who meet a long-term residency requirement, usually living in India for 12 straight years. And finally, by incorporation of territory. Like, if India acquires a new territory, say Puducherry or Sikkim back in the day, the government offers citizenship to the people living there.
But here's a really fascinating legal catch regarding registration and naturalization. Just fulfilling those residency requirements, like living there for 12 years, that only makes you eligible to apply. It absolutely does not mean you can demand citizenship as some guaranteed right. The final call rests entirely with the government of India. Why? Because citizenship is strictly a union list subject. The central government always has the final say.
Which brings us to Section 3, losing Indian citizenship.
We've built the foundation, we've acquired the status, but it's super important to realize that Indian citizenship is not some permanent, unbreakable guarantee. So, how can it actually be lost? What could possibly strip away all those fundamental rights we just talked about? Well, the law lays out 3 distinct ways.
The first 2 are basically voluntary. Number 1 is renunciation. If you get citizenship in another country and voluntarily hand back your Indian citizenship, that's formal renunciation. But remember, India strictly prohibits dual citizenship. So what happens if you get a foreign passport but just don't tell the Indian government? That triggers the second method, termination. If you acquire another country's citizenship without formally surrendering your Indian one, your Indian citizenship is just automatically terminated by law. Simple as that.
But that third method, that one is involuntary, and it is severe. Deprivation. The government of India can forcefully strip someone of their citizenship under some very strict conditions. Like what? Well, if the citizenship was acquired by fraud or hiding facts. Or if, within 5 years of getting citizenship, the person gets thrown in prison for at least 2 years. Another ground is illegally communicating with the enemy during a war. And finally, living outside India for 7 consecutive years without being a student or a government employee and showing zero intent to return.
Let's move along and see how this builds into an actual legal process. Because deprivation is such a huge deal, the government can't just snap its fingers and revoke your status. The notes outline a very specific process of deprivation. First, a formal inquiry has to be conducted by a specific committee. And second, to make sure it's legally fair, that committee has to be headed by someone who has held judicial office in the country for at least 10 years. The state really has to prove its case.
Okay, Section 4, Overseas Citizens of India, or OCI.
Let's bring this into the modern era. As Indians migrated all over the world, a massive diaspora formed. And that rigid ban on dual citizenship? It started creating real challenges. The government had to adapt. You can see the evolution right here on this timeline. In 2003, an amendment offered a sort of dual citizenship for persons of Indian origin, or PIOs, living in just 16 specific countries. By 2005, they realized this was a global need, so they expanded it to PIOs and OCIs worldwide. Then, in 2015, they streamlined the whole shebang and fully merged the older PIO card scheme with the OCI card scheme.
But what is an OCI cardholder? Exactly. Well, it's a careful balancing act of benefits and restrictions. The perks are mostly economic and logistical. An OCI cardholder can travel to India visa-free. They can buy property, though not agricultural or farmland, and they can make direct investments. But the restrictions are absolute when it comes to the state. 0 political rights. You can't run for office, and you definitely can't vote. Also, it's worth noting that citizens of Pakistan, Bangladesh, and any other country specifically notified by the government are strictly ineligible to even apply for this status. Finally, Section 5, the 2019 Amendment Act.
This is the most recent major update to the framework we've been exploring today. You probably know it as the CAA. We're going to look strictly at what the source text says it does. So the crucial point is understanding the precise parameters. The CAA seeks to fast-track citizenship for 6 specific religious communities: Hindus, Jains, Sikhs, Buddhists, Christians, and Parsis. It applies explicitly to individuals from these groups who illegally migrated from 3 specific neighboring countries, Pakistan, Bangladesh, and Afghanistan, on the grounds of facing religious persecution there. And finally, it sets a hard cutoff date. To be eligible, a person from these groups must have entered India on or before December 31, 2014.
If they meet all those criteria, we hit this vital number, 6 years. Under the standard naturalization laws we talked about earlier, you usually have to live in India for 12 years. The CAA changes that for these specific groups, allowing them to acquire Indian citizenship within 6 years. It's essentially an acceleration of the naturalization process.
Now, what's really interesting here are the geographic exemptions. The Act doesn't actually apply uniformly across the whole country. According to our notes, the CAA is explicitly not applicable to the tribal areas of Assam, Meghalaya, Mizoram, and Tripura. Plus, it's also not applicable in the entire state of Arunachal Pradesh. It just goes to show the really complex regional demographics and autonomous structures built into the Indian legal system.
And that brings us to the end of our explainer. From those foundational definitions back in 1949, through the systematic rules of 1955, the creation of OCI cards, right up to the 2019 CAA. Looking at all this leaves us with a pretty profound question. How exactly does a nation balance its permanent constitutional ideals of full membership and equal rights with the constantly evolving legislative laws needed to navigate history, migration, and geography? It's a lot to think about. I hope this structured look at the source material has given you the clarity to explore that very question further. Thank you so much for learning with us today.